Not at all. There is ample basis to disagree with the reasoning of this decision, because I think the judge got it wrong on many folds. But even before I go into the decisions I think she got wrong, it is important for us to situate this discussion in a certain context. This is a conversation about justice and justice delivery. It's a conversation about the ethical and professional conduct or misconduct of a person in whom the prosecutorial powers of all of us is vested. And we must all know that the issue of justice affects all of us. And so in discussing this important issue of justice, the very foundation of our existence and democracy, let's be fair, let's be objective. I don't say that Ofredame is my friend or my party member, so even when I know that this is wrong, I will try to defend it. Now, there is something good that the judge has done that I have been commending her for, and I want to reiterate that commendation. It has to do with the judge delivering a detailed, well-reasoned ruling in a matter that she could have just given an off-the-bench ruling.
Really?
I mean...
You can't give a bench ruling on this?
Well, she says she could. She had the discretion.
Oh,
so she said that.
So?
Yes, on the day of the ruling.
That
she had the discretion to give an off-the-bench.
Five applications of such serious
She said she had the discretion. And so for me, to give this detailed 34-page, 14-page rulings, commendable, okay? At least it helps the development of the law. Another thing that I commend her for is the admission of Exhibit CAF 2, the audio recording, which was played by the NDC at our press conference sometime last 2 weeks, which our friends in the MPP, led by the likes of Frank Davis, Nana B, Paul Adomotre, and so on, said was doctored. In fact, the words of Frank David were that the tape on this very platform in this chair had been spliced together, and I'm quoting him, spliced together, which goes to the authenticity of the tape. Now, the public and viewers of Newsfile need to know that when this tape was brought to court, the Attorney General could not raise any objection to its authenticity. The Attorney General did not mount any challenge.
But he was not given the opportunity to make an argument.
No, hold on. The Attorney General had an opportunity to file an affidavit in opposition. He could not, you will not interject. You will not.
Go ahead.
He could not
the tape was attached to a
supplementary affidavit. Yes. Yes. So the Attorney General could file a supplementary affidavit in opposition. In the first place, he could not swear an affidavit in the first place. He had to employ the services of a proxy.
Which is
material.
Which is allowed.
No, I will tell you why it is not proper. But the Ghanaians need to know that Godfrey Dami could not swear an oath to deny the authenticity of the tape.
It is allowed in law for him to get someone else to swear an oath on the matters that have been brought against him.
The law only allows that person to swear that oath on his behalf if that person declares his source of the information.
The source will be the Attorney General.
Yes, and I'm saying that, no, that source, if that source is the Attorney General, then that is hearsay. But in any case, for the ordinary man watching, why would the Attorney General, who has always been in court, and against whose person these allegations are being made, decide to defer the denial of those serious allegations to a proxy when he himself can go under oath? Because he knows the repercussions.
The counter is that you were setting a trap for him.
Oh, why?
That once he swears to the affidavit, he's the one going to make the argument. He's going to refer to his own
but even non-lawyers sometimes are allowed to testify.
And then secondly, once he swears to the affidavit, you may also apply to the court to cross-examine him on it.
Yes, but why is he afraid of?
He has a right. He has a right not to want to speak to it.
Let me tell you what he was scared of, in our opinion. He was scared of lying under oath because he knows that if he swears that affidavit and it is found out that anything in that affidavit is false, he will go to jail for
That's a presumption.
Now, and yours too is a presumption. So, something, the point here is that all the things the MPP have been saying about the tape being doctored, spliced together, they could not say it in court. The only challenge that Attorney General raised on his feet was a challenge on grounds of breach of the right to privacy.
Article 18.
And like we rightly said here, the judge upheld our argument that that right is subject to exceptions.
And last week we said that even if it is stolen,
it doesn't
once
matter.
It is intended to
once
crime.
You are committing crime in your privacy, or you are violating the fundamental human rights of another person in your privacy, that right to privacy does not hold. And the judge dismissed those allegations and admitted it. So the lies, your friends in the MPP, the tape is doctored, all that has fallen flat, number one. Now let's go to the things the judge got wrong. Number one, the issue of Odi Oterem pattern. I have a total different view. The issue of whether or not an application has been moved is different from the issue of whether or not the court has a discretion to allow legal arguments. Lawyer Tadiosore and lawyer Aziz Bamba are not complaining because they were denied the opportunity to make legal arguments, even though they would have preferred so. And in my opinion, the judge should have allowed for oral arguments in his discretion, because the judge herself concedes that this is a novel legal issue. And the norm is on such novel legal issues, the judge, in exercising his discretion, would want counsel to address the court on certain important matters so that justice can be done. That was a discretionary matter, governed by Article 296. And I think that the manner in which the judge exercised the discretion in disallowing legal arguments was an abuse of her discretionary power under 296. But the most important point here is about whether they were heard or not. On whether they were heard or not, it is clear that they were not heard, because like you rightly pointed out, when an application is filed, it has a filing date and a hearing date. And it is written boldly on the face of the application that court to be moved on so and so dates. You go to court, the norm, as I have seen within the short time that I have been a lawyer, the norm is that the court, once counsel for the applicant is always in court, the court will always ask the counsel for the applicant to move the motion and say, my lord, I have before you a motion for so and so, pursuant to so and so. I move in terms of the motion paper, the supporting affidavit, and exhibit. That at least is always allowed by the courts.
Not always.
Why?
In practice,
yes,
if you are using the court every day as a practitioner, you will know that in practice. You can file an application. I have an ex parte motion. I go there. The judge doesn't need me to move it. They will say, yes, counsel, I've seen your affidavit in support of it. It is granted. Go.
No, you see, you can talk about what some judges do. I am talking about what the law requires. That once parties have brought a matter before you, the least you can do for them is to give them a hearing, not legal arguments. The legal arguments point, I've dealt with it. It's
but if it is just about the facts,
governed by 296.
If it's just about the facts, then the facts are already on the affidavit.
This was not just about the facts. This is the case where a preliminary objection had even been raised.
All right.
So once you deal with a preliminary objection, you then move to the application proper, and counsel should be allowed to say something about the application that has been filed. That was not done. But the most serious thing was that an application had been filed in the Supreme Court seeking to restrain the judge from delivering the ruling that day. And the judge sits in open court and says, even if I am held in contempt, I will come to you as a lawyer to defend me. Is this something that we want to encourage even ordinary men in society to do? That today we have a president of our country saying that because the matter is pending in the Supreme Court, I will not exercise my constitutional powers, right? To assent or refuse assent of a bill because the matter is pending in court. And the judge says, yes, you have filed it, but I will still go ahead, and if the Supreme Court holds me in contempt, I'll come to... Please, I thought that
basically
left much to be desired.
So basically they were seeking to arrest the ruling so that she doesn't deliver.
Exactly.
Okay.
Number two, the judge was terribly wrong when she said that there is no statute that confers on her jurisdiction to give orders for inquiries, mistrial, and so on. Because Article 140 of the 1992 Constitution is clear.
Criminal law.
Yes.
Criminal law.
The High Court.
Criminal law.
Yes.
Criminal law derives from the law itself.
Yes.
The judge's jurisdiction
Yes.
must be statute-based.
Yes, I'm coming. So let me read to you.
Should we debate this?
Yes, and I'm trying to tell you that there is statutes.
No,
that
you are reading article...
Hold on.
You are reading the Constitution on general jurisdiction for the court to exercise.
Hold on.
Yeah.
The High Court, 141, shall, subject to the provisions of this Constitution, have jurisdiction in all matters, and in particular in civil and criminal matters, and such original, appellate, and other jurisdiction as may be conferred on it by this Constitution and any other law. So the Constitution grants the High Court jurisdiction in all matters, civil and criminal, subject to the provisions of the Constitution.
Fortified by statute. It said there, right there, fortified by statute.
No, where is
and
the
it's
statute?
A statute that,
where? There is no statute here.
That delimits the
There is no statute or any known law that says that a court, number one, cannot exercise general jurisdiction in criminal matters or inherent jurisdiction in criminal matters. So you allow me to make my argument. I'm saying that 141 doesn't talk about any statutory jurisdiction. It says that the High Court shall have, subject to the provisions of this Constitution, have jurisdiction in all matters and in particular in civil and criminal matters. Now, there are decided cases on this, right? Decided cases. If you look at the case of Republic versus High Court, Kufuridua, S. Party Nyame, and another, right? The court was clear. This is what the court said. Nothing was presumed to be out of the jurisdiction of the superior cause unless expressly so stated. But nothing was presumed to be within the jurisdiction of the lower cause unless specifically stated. I can go on and on and on. Now, this is the point. Once the supreme law of the land has given you general jurisdiction in all matters criminal and civil, our contention is that unless, based on this decision, a law expressly takes away or outs that jurisdiction, you cannot say you don't have jurisdiction.
She points to the provisions of the criminal and other offenses.
Which doesn't apply to the case, Section 8. Which doesn't apply.
Which pertain to jury trials. And she says, no, mistrial in any case happens in jury trial.
It's not true.
This is not a jury trial.
Let me even show you why it is not true.
Say you disagree.
I disagree. The reason why I disagree is that even apart from the general jurisdiction she has, and on the basis of the decided case the authority have cited, shows that until that a law expressly takes away or outs that jurisdiction, she has to exercise it to do justice. There is such a thing as the common law, which is part of the laws of Ghana. Article 11(1)(e).
And common law must not be mounted for criminal...
No, there is no law. What the law she cited says is that you cannot prosecute and convict a person under the common law. We're not asking for Godfrey Dami to be prosecuted. We are asking you to make orders subject to the common law. That is what Dr. Bassett asked. And this is the point. It is very clear, and I can cite another case to you, okay, that every court, especially superior courts, let me put it that way, has inherent jurisdiction to provide for matters not even provided for in statutes. And if you look at the common law, courts trying criminal matters have inherent jurisdiction to prevent the abuse of their processes, the processes of the court, and to ensure fairness in the legal proceedings. Some say you understand. And in so doing, under the common law, courts trying criminal matters are able to make orders for inquiries, orders for mistrial, and so on. And that common law per Article 11(1)(e) is part of the laws of Ghana.
Okay.
Aside that, there is Article 12(1), which enjoins all organs of states to uphold the fundamental human rights of all citizens or all persons in Ghana. 19 talks about the right to a fair trial. Article 142 gives the High Court jurisdiction to enforce fundamental human rights. And then you cannot say that if in the course of hearing a criminal matter, the right of an accused person to a fair trial is being violated, the court will not exercise inherent jurisdiction to prevent that abuse of that right. Again, the court got it terribly wrong in assessing the evidence that was placed before the court. Who can listen to this audio you have played this morning and say, in good conscience, Samson, that Dame did not ask Jakpa to implicate Atuforsen. You hear in the tape at several points Dame telling Jakpa to testify his way, and that was not going to create any difficulty for Jakpa. What was going to be the effects of those testimonies or answers he was soliciting through that unprofessional way from Jakpa? If Jakpa went to court to testify the way the AG wants, i.e. saying that payment was made via letters of credit even before goods were shipped, was that not going to implicate Atuforsen for willfully causing financial loss to the state? The judge makes no reference to those portions of the tape. Then the judge goes to the part of the tape where Jakpa is heard saying that if I do this, I will be dishonest. The judge says those were the words of Jakpa. But
that's true.
Yes.
That's true that those were the words of Jakpa.
Yes, but in assessing evidence, you assess it, number one, as a whole. Number two, a judge is allowed to make inferences in assessing evidence. And so if in a conversation, I tell you, Samson, that you told me to go and implicate somebody, and that if I do that, I will be dishonest and I will be sending an innocent person to jail, and you have not done it, what is a reasonable person, any right-thinking person will do? Deny. Dame never denied. The only thing Dame said, that this is a telephone conversation, I don't know whether I'm being recorded. That statement in itself shows that Dame had an ill mood.
He hasn't said...
And the judge is saying...
Wait,
no.
Dame hasn't said this, but let me play the devil's advocate again.
No,
hold on. Let me tell you this. Let me tell you this.
Yes, where the court has done it right, we have the right to commend it. In our opinion,
Sammy,
where
hear
we
me.
disagree,
Sammy, hear me.
Express our divergent opinion.
Sammy, hear me. And last week we went through this, and many people came at me that I'm heckling you. I'm getting the best out of you.
No problem.
Now watch this.
That's that you must give me the time to.
And for you who think this way, I have no any such intentions.
Yeah.
Now, Dame has not said this.
Yes.
But imagine when they say the tape has been pieced together.
Yeah.
It is possible that where you are expecting the judge to make an inference, that inference could lead into trouble when there is the full audio provided somewhat, and it shows that he had protested that comment, and yet that was cut off.
Senior, respectfully, that is a red herring because the judge herself, Dame herself, did not raise any issue about the incomplete nature of the tape. And the judge never made any reference to any incomplete tape. You understand? So that was not even one of the things she considered. In this case, ask yourself, why did Jakpa say on the tape that I cannot help you, and that if I testify the way you want, I answer the questions the way you want, I will be helping you to convict an innocent person? It is because prior to that, the Attorney General had told him that, look, this is very simple. If you do this, if you agree to this,
it won't create any
problem. Then he replies by saying, I can't do that because if I do that, I will be helping you.
So
then
bottom
he
line,
continues. Then he continues and says,
we need to move on.
No, then he continues and says, I have been having several meetings with you in my cousin's house. Dame doesn't say, no, I have not been having meetings with you. And the judge says, because only one party on the conversation said this, then it is not true. And he, my senior at the back, Gary, and the judge, they say that, oh, this is a tape that only made 2 weeks ago. Really? The tape contains evidence of interactions with Mr. Jakpa that happened as far back as 2022, the outset of the case in court. And if you look at Jakpa's affidavit before the court, he speaks about interactions with the Attorney General as far back as 2022, for which reason he says... Hold on.
Gary's question is, why didn't he bring that in the process?
For which reason, Mr. Jakpa says the whole case has been brought in mala fide and not bona fide. Why didn't he raise it at the beginning is neither here nor there. Jakpa is now doing his case. Atuforsen has not been in meetings with Godfrey Dame. Jakpa is now doing his case, and this is the right time. Now, let's make something clear for those who are learning.
I need to move on.
Because sometimes you ask a certain question which may give a wrong impression. Godfrey Dame has not been acquitted of any charge of misconduct.
Godfrey Dame has not been charged with any charge of misconduct.
Yes, and he has not been acquitted. What the judge said at page 8 was simply to play Pontius Pilate. That my forum is not the right forum to pursue issues of professional misconduct against the Attorney General.
That you agree.
And that there may be another forum.
That you agree, don't you?
I disagree because the court is also a forum. The two are not mutually exclusive.
A forum for punishment for misconduct.
Every superior court has an inherent jurisdiction to ensure that, number one, its processes are not being abused.
Even in the Supreme Court.
Yes.
When Nekwe Tete's matter came up,
yes,
the court had to make a referral
that
to
is
the General
different.
Legal Council.
Talking about a prosecutor.
They didn't punish.
Look, you are saying that if a prosecutor, in the cases, the Canadian cases and the Senate cases, the judge cited, what was the substance of the case? What was the issue? It was about prosecutors prosecuting people for crime, engaging in misconduct, and those courts being called upon to say that, look, your processes are being abused, accused persons are not likely to get a fair trial, therefore invoke your inherent jurisdiction to prevent that and to protect the rights of the accused person. You can't say that a judge in a superior court trying a criminal matter doesn't have that inherent jurisdiction. And so something finally, what I will say on this matter
in a minute
is that for Godfrey Dame to be strongly advised by a judge as Attorney General to stay away from a criminal matter he is prosecuting, and the judge gave her grounds. She says, I strongly advise you to do so to protect justice, and so that the public will have confidence that matters before the court are only determined in the court and not elsewhere. This is the most damning verdict ever given by a court against any Attorney General from the days of Geoffrey Bink. And it shows what a disgrace Godfrey Dame is. And this is the more reason why he must go. And if he doesn't go,
the application to prohibit the judge is still triggered. Has been filed and pending in the Supreme Court,
the application to do what?
To prohibit her, yes.
Yeah, that one is still there. So, I think that
so there's a possibility. There's a possibility.
Yes. And an
that
appeal
the Supreme Court will hold that what she did was wrong. There's a possibility. So
but whether that in itself will invalidate the ruling, that's another matter. Gary, but I am very sure that there will be
just a minute
an appeal.
Because we have to move on.
I know that there will be an appeal.
Because I won't get him to speak again.
Give us more time.
No.
Because
we go to the next
we can do it 30
No.
5G. You see, this one is about justice.
My brother,
5G, we have more time.
My brother has really misled the public.
And a minute.
Correct that one. You see, on the issue of the source of the source of the tape. That was in the position. Tados conversed it, and the court overruled it. So you don't say that the court didn't deal with that matter. It was overruled in the court, European court.
What?
I mean, the issue about the source of the tape.
No. The source of information of the principal state attorney who testified, who saw that affidavit for Godfrey Dame. So you are missing the issue.
Thank you.
Look. Yeah.
My time is up.
You asked the question about something I said about the judge saying that it is settled that the ambulances could not be used. Let me clarify that point in 1 minute.
No, something.
What we disagree? Oh, senior.
No.
I'm sorry. I'm your
okay, so when you are done, you know in
1 minute. I will just do this.
I'm holding
for
2 minutes, then you do 2 minutes.
The reason why we are saying that statement the judge made was very wrong and unfair is that as we speak, at the time she was giving the ruling on this matter, these 5 applications, it has not been settled per the record of the proceedings that the ambulances in the states they were brought into the country could not be used. What is the evidence of Mr. Jakpa is that the ambulances in the state they were brought in were not supposed to be used. And that there was an agreement to that purpose, that the medical accessories must be shipped later, installed, before they were used. And that if they were even used, in the state they were brought in, it was going to void the warranty.
You are making the same statement differently.
No. Could not. If you say, when you are trying people accused of a crime, that already it has been established that the ambulances were not fit or could not be used, that is serious. You are trying to say that already.
Could not be used until what you have said ought to have been fitted.
No, she didn't say until.
She added it. I'm rendering it that way.
You see, there has not been any settlement of any facts that the ambulances as they were brought in could not. What the agreement is that, what is the case, the testimony of Jakpa is that the ambulances were not supposed to be used in that state. The ambulances have not even been handed over to the government.
Something.
The medical accessories are still at the port for 7 years.
Okay.
Something.
Okay.
So how does the issue of loss even arise? Well, the court will determine.
Gary, wait, before you come in.
Okay.
It has to be
Yes.
made clear here that, in fact, the judge did not make a prejudicial
You read
statement.
it. You will see
did
the
not
prejudicial
prejudge
statement.
the whole thing.
You read it.
That
They
is
could not be used is the issue.
Okay.
Because that is not the testimony of Jakpa. Jakpa's testimony is that they are not meant to be used.
I didn't.
If you say could not be used, what you're invariably saying is
I highlighted it, but didn't mark the page. But which page is it?
Page 4.
Page 4. Thank you. So on page 4, yes, he says, the matter was settled that the ambulances, then she begins to highlight.
Yes.
In the state that they were delivered,
highlight ended.
Could not serve any useful purpose. Wait. She doesn't end there.
Yes.
But the assertion was made per the cross-examination and other evidence put forward, particularly by Jakpa, that there were moves to fix the defects, thereby proffering the case that there was no loss occasion to the state.
Yes.
So this is fair to the
Jakpa is not only saying that there were moves to fix. Jakpa is saying that the ambulances were not intended to be used in the first place.
Thank you. Point
until the right accessories were installed.
Yes, thank you.